Subcommittee on the Environment will come to order. Without objection, the chair is authorized to declare resources of the subcommittee at any time. Welcome to today's hearing entitled Examining the EPA's Regional Haze Program, Regulations Without Visible Benefits. I recognize myself for 5 minutes for an opening statement. Today's hearing focuses on EPA's Regional Haze Rule. As the Obama administration nears the end of its time in office, we must carefully review the impact, costs, and achievability of any rules and implementation plans this activist EPA attempts to put in place on the way out the door. As we will see, the benefits of this regulation are dubious, but the cost to individual states, including my home state of Oklahoma, will be very, very high. Unlike the other regulations promulgated under the Clean Air Act that this committee has examined, the Regional Haze Rule is unique for two important reasons. First, it is an aesthetic regulation and not a public health regulation. These rules were designed primarily to ensure the public can clearly see the sites at national parks and other natural landmarks. Second, Clean Air Act legislative history specifically gives individual states a unique degree of authority to be decision makers when implementing visibility improving policies. Over the past several decades, visibility levels at many of our national parks and wilderness areas have significantly improved, due in large part to the efforts of individual states, working together with stakeholders to implement plans at the state level. The EPA did not object to the state plans then, recognizing our system of federalism. But under this president, the EPA has overruled the plans created by many states to comply with this rule, instituting federal implementation plans in 14, including Oklahoma, 14 states, and attempting to institute federal implementation plans in 2 more. These federal plans will have huge implementation costs, hurting consumers, those on fixed incomes, and small businesses. It will force coal-fired power plants to shut down and make electricity generation more expensive. OG&E and AEP PSO, utilities in my state, have had to shut down power plants, forcing them to propose rate hikes or else go out of business. I will remind my colleagues about the multitude of economically detrimental, radical regulations pushed by this administration, including the Clean Power Plan, Waters of the U.S., and the National Ambient Air Quality Standards for Ozone. And now, in a continuation of its war on the poor, the EPA is using, quote, visibility improvement, unquote, to force utilities and other stakeholders to further move away from coal and other forms of cost-effective power generation. What's worse is that the improvements to visibility will be negligible. Many of the EPA's own visibility goals have already been achieved. Further, the scientific justification for this regulation is shaky and questionable, as our witnesses will testify. The EPA is instituting more stringent controls for visibility than it would for even health-based regulations. The precedent set in this rule, requiring additional controls with no real benefit while requiring controls on individual generation sources, could have significant and draconian ramifications for regional haze planning across the country. This is yet another example of the federal government bullying my constituents. Later this spring, the committee will invite the EPA so that it will answer questions as to why it has become a radical political arm of the Obama administration and why they are rushing through a vast number of hasty, non-scientific regulations, including regional haze implementation plans. The EPA needs to be held accountable to the American people. We welcome the witnesses today and look forward to their testimony. I now recognize the ranking member, the gentlewoman from Oregon, for an opening statement.
Thank you very much, Mr. Chairman. Thank you to our witnesses for being here this morning. On August 25th of this year, the National Park Service will celebrate their centennial, so it's fitting that we're discussing EPA's efforts to reduce regional haze and maintain the scenic outlook of our most treasured locations. President John F. Kennedy said of the creation of the National Park System, "It is the course of wisdom to set aside an ample portion of our natural resources as national parks and reserves, thus ensuring that future generations may know the majesty of the earth as we know it today." In 1977, Congress had the foresight to take President Kennedy's sentiment to heart, and they recognized the threat that air pollution posed to our iconic parks, and they called on the EPA to reduce regional haze. Some may think that preserving the views in our parks and wilderness areas isn't worth the cost, but clearer skies actually have a direct effect on the economy, especially in the local communities that surround our national parks. Studies have shown consistently that park visitors will cut their trips short if the park they're planning to visit is hazy. Shorter trips and fewer visitors means less money spent on recreational activities, lodging, food. For example, in 2014, more than 500,000 visitors traveled to Oregon's Crater Lake, supporting more than 760 jobs. As a whole, our national park system had 293 million visitors who added $29.7 billion to the economy and supported 277,000 jobs. We should be doing more, not less, to protect these iconic landscapes and the local economies they support. I'd like to put up a slide that shows the progress we've made, there we go, under the Regional Haze Program, and emphasize that there are visible benefits, but still work to be done. This slide shows a side-by-side comparison of the Great Smoky Mountains, illustrating the air pollution that existed in 1990, the clearing that occurred in 2010, and the goal of natural visibility, excuse me, that still needs to be achieved. In 1990, a park visitor could see 25 miles out. In 2010, 46 miles, and with natural visibility conditions, they can see 112 miles of this magnificent mountain range. Now, I know some consider EPA's efforts to improve air quality under the Clean Air Act, including the regional haze rule, to be a war on coal. Well, I want to mention that earlier this month, my home state of Oregon, became the first state to enact bipartisan legislation to eliminate the use of coal-fired power by 2035. And we did this because coal-fired power plants are some of our biggest polluters. And if we're going to make significant progress in combating air pollution in the future, we need to transition to cleaner sources of energy now. Such a transition will provide economic opportunities, improve public health, and preserve the majesty of our national parks for future generations. Mr. Chairman, I have a letter from the National Parks Conservation Association that I'd like to submit for the record. The letter describes the importance of clean air to our national parks and the need for the Regional Haze Program. Specifically, the letter states, a steady reduction in haze-causing pollution is precisely what is required under the Regional Haze Rule to safeguard our iconic landscapes, support local communities, and protect the health of all. I ask unanimous consent that the letter be part of the record.
Without objection.
Thank you, Mr. Chairman. I look forward to the testimony of our witnesses, and at this time, Mr. Chairman, I yield back the balance of my time.
Thank you, Ms. Bonamici. I now recognize the chairman of the full committee, Mr. Smith.
Thank you, Mr. Chairman, and thanks to our witnesses for being here today as well. The Science Committee has held many hearings on the regulatory overreach of the Environmental Protection Agency during this administration. Unfortunately, the EPA is again attempting to unnecessarily and unlawfully regulate the lives of the American people. Throughout this Congress, the committee has often revealed how the EPA's regulatory overreach will cost billions of dollars, cause financial hardship for American families, and diminish the competitiveness of American employers, all with no significant benefit to climate change, public health, or the economy. The EPA has rushed through many costly and burdensome regulations. Examples include the strict new National Ambient Air Quality Standards for ozone, waters of the U.S., and the Clean Power Plan. Today, we will hear how the EPA's interpretation and execution of the Regional Haze Rule unlawfully undercuts the statutory authority of the individual states. Congress clearly intended, through the Clean Air Act, that individual states be responsible and in charge of the program, not the federal government. Instead, the administration is determined to use this rule to impose more costly regulations on Americans. In my home state of Texas, the EPA's regional haze imposition would affect 14 power plants and cost more than $2 billion. This past Friday, the Attorney General for Texas requested a stay of this plan. EPA's regulatory agenda is bad for the American economy and for the American people. We cannot allow a federal agency to assume power that Congress has not given it. The Science Committee will continue to rein in the EPA when it oversteps its authority. Contrary to the EPA's agenda, Americans want to be free from overly burdensome regulations, not tied up in more. We look forward to EPA's presence at a future hearing. EPA will also be expected to answer questions about other regulations that the agency has recently issued or finalized. Thank you again, Mr. Chairman. Yield back.
I'd like to thank the chairman for his opening statement. I now recognize the ranking member of the full committee for an opening statement.
Thank you very much, Mr. Chairman. Welcome to our witnesses. We're here this morning to discuss the Environmental Protection Agency's Regional Haze Program. Nearly 40 years ago, Congress called on EPA to implement a program that would address air pollution in the most iconic and unique places in our country, our national parks. Members of Congress wanted to ensure that future generations would be able to enjoy these scenic vistas and that our view would not be marred by discolored haze. While the nation's air quality has improved over the years, in part because of programs like the one we're discussing today, there's still more that needs to be done. When someone visits a national park today, they miss out on nearly 50 miles of scenery because of regional haze. This pollution doesn't just spoil the view, it also has a negative impact on public health. Unfortunately, officials from my home state of Texas are not leading the charge to reduce air pollution, but instead of fighting the EPA once again. Last month, the Texas Attorney General, Ken Paxton, filed a lawsuit against EPA after the agency rejected the state's plan for reducing regional haze and replaced it with a federal plan. As I understand it, the Texas plan did not include a single additional pollution control on any of the state's facilities. I'm not sure how the state expected EPA to agree that such a do-nothing plan would qualify as making reasonable progress toward the program's goal of eliminating haze pollution and restoring natural visibility conditions. Some will likely argue that the pollution controls EPA is requiring will not have sufficient impact on visibility at the Big Bend or the Guadalupe Mountains. They will also argue that the controls are too expensive and that the reliability of state's electric grid would be threatened. This certainly is not the case. EPA's plan represents a cost-effective solution to addressing regional haze. The EPA's plan will not only ensure that visitors to the Big Bend and Guadalupe Mountains can enjoy the scenery for years to come, but it will help lessen the public health burden of poor air quality has imposed upon Texas for too long. So, Mr. Chairman, I thank you for holding this hearing, and I yield back the balance of my time.
I thank the ranking member. I have a number of pages here of bios to read. We have votes at 10:30, so without objection, I'll bypass on the bios and suffice it to say that we have 4 very qualified panelists today testifying. All of them have numerous degrees, and they all care deeply about their communities and their country. With that said, I'd like to now no objection. With that said, I'd like to now recognize Mr. Yeatman for his opening statement of 5 minutes.
Thank you. Chairman Bridenstine, Ranking Member Bonamici, Committee Ranking Member Johnson, and distinguished members of the subcommittee, thank you very much for inviting me today to testify before you on EPA's implementation of the Regional Haze Program. My name is William Yeatman. Very briefly, I work at the Competitive Enterprise Institute. We're a libertarian think tank here in Washington, D.C. With my testimony, I just want to briefly touch upon 2 themes as they relate to the Regional Haze Rule, and that's federalism and cost as against benefits. So first, under the Clean Air Act's framework of cooperative federalism, states and EPA are supposed to work together to improve the nation's air quality. Now, in this arrangement, the most aggressive action that EPA can perform relative to the states is a regulatory takeover. It's known as a Federal Implementation Plan, or FIP. And these FIPS are a big deal. They literally are EPA seizing a small piece of state sovereignty. Because these FIPS, these regulatory takeovers, are a big deal, they've been employed sparingly, very sparingly, by previous administrations. For example, the previous 3 administrations, presidential administrations, George H.W. Bush, Bill Clinton, and George W. Bush, among them, EPA imposed 5 total regulatory takeovers across all Clean Air Act programs. Now, by contrast, since 2009, EPA has imposed 15 FIPS, and that's just in the Regional Haze program. So you take the previous 3 administrations, their total number of takeovers across the entire Clean Air Act, you add them up, you multiply them times 3, and that's how many we've had from the Environmental Protection Agency since 2009. So this raises significant federalism implications. At the same time, it raises cost concerns. By my estimate, these regulatory takeovers will amount to costs of at least $5 billion. That's in capital cost up front. And this burden will fall primarily upon about 7 states, including Oklahoma, which again, the residents of Tulsa and Oklahoma City are facing rate increases of 14% and 20% respectively, and that's just the beginning and is due to the Regional Haze Rule. Again, these costs fall disproportionately on the poorest among us. They're regressive. The poorest among us spend more on energy as a proportion of their income. So we've got these federalism concerns. We've got these regressive costs. You might think to yourself, well, geez, EPA must have a really good reason to do this, to perform these acts. And in fact, the case is, or alas, that's not the case. I mean, the benefits are literally invisible, and we can demonstrate this with computer modeling, or software, I should say, known as WinHaze. We can model the visibility improvements attendant to EPA's controls relative to the state's controls. And if we could please get the first. So this is a split screen image. On the left, those are the state controls, so 50% of the screen. That's what Oklahoma did. Thousands of hours of work they put into a plan, more than 1,000 pages. Those are the visibility benefits. So on the right, those are the visibility benefits attendant to EPA's controls. And again, those are invisible. No reasonable person is going to tell you there's a difference there. And again, the cost is $1.8 billion. So big time cost and visible benefits. I should note that this is the greatest visibility improvement wrought by any of EPA's FIPS. So there's no state whose, I guess, benefit, if you will, is greater than this. If we could get the next slide. This is Texas. So similarly, this is actually a visibility benefit 1/6 of the previous slide. Texas, their implementation plan on the left, EPA is on the right. EPA deemed Texas's plan insufficiently protective of visibility, and based on that, imposed this plan for $1.7 billion. I mean, there's no difference. I mean, it raises serious questions about, I guess, again, cost versus benefit. So those were the themes I wanted to brush upon. Just in general, this plan raises serious federalism concerns. It imposes regressive, significant costs, and the benefits are literally invisible. Thank you very much. I look forward to the Q&A.
Thank you for your testimony. I now recognize Mr. Thomas Schroedter, Executive Director and General Counsel of the Oklahoma Industrial Energy Consumers.
Thank you, Subcommittee Chairman Bridenstine, and thank you, members, for the opportunity to be here. I am the Executive Director of a trade association called OIEC. It is a trade association of energy-intensive manufacturers, refiners, transporters, and other large energy consumers. They have facilities located throughout the state of Oklahoma, and the member companies employ tens of thousands of Oklahoma. Many of those members are engaged in energy price-sensitive industries such as pulp and paper, cement, refining, industrial gases, plastic, food processing, fertilizer. As I say, these members provide tens of thousands of jobs to the state of Oklahoma. My testimony is going to address the impact of the Regional Haze Rule on the state. Unfortunately, Oklahoma spent a lot of time coming up with a state implementation plan to address regional haze. But unfortunately, that plan was rejected. It was rejected by EPA in December of 2011, and EPA insisted that the state of Oklahoma plan provide for scrubbers on 6 coal-fired generating units. Now, those scrubbers were very expensive, and the state of Oklahoma determined that the scrubbers were not cost-effective, that they should not be implemented, and instead that the utilities in Oklahoma should move to low-sulfur coal, and they could comply with regional haze by doing that. As I said, EPA disagreed, and EPA imposed a federal implementation plan. What happened after that, OG&E went to court, went to the 10th Circuit. PSO, the other investor-owned utility, negotiated a settlement with the EPA. But I want you to know that the bottom line of what's happened or what will happen in Oklahoma is that we will incur substantial rate impacts for all utility ratepayers, whether they're residential, whether they're small businesses, whether they're large energy consumers, such as my members. The first-year rate increases, and you're going to hear lots of numbers today, but the first-year rate increases are estimated to be 11 to 12%. But that's only year one. Based on an analysis that we have done, and I don't think that many will disagree with, the OG&E will expend more than $4.2 billion in excess costs in order to comply with regional haze. I have a slide on that. The nominal cost to comply over the life cycle is basically $4.5 billion. The other utility, PSO, will expend approximately $5.1 billion more than the Oklahoma State plan. And the reason PSO's plan is more costly is they are closing their coal plants. They're converting them to natural gas. These are very serious ramifications, members, that I'm pleased that you've given me the opportunity to share with you. One of the ramifications is that basically we will be left with reliance on natural gas fire generation. And that means loss of diversity. It's like investing in the stock market and only investing in one stock. We will be heavily invested in one fuel supply, and that's not good if that price increases. As you know, as energy rates go up, there's a potential for increased unemployment. And we've looked at that, and unfortunately, the regressive nature of the regional haze federal implementation plan means that as you get to lower income consumers, the impact is greater because more and more of their income is spent on energy. So this is bad for all consumers, not just large consumers like my members, but large consumers. It's bad for Oklahoma. It will impact the competitiveness of Oklahoma. I can tell you that my members, if it becomes too costly to manufacture, will either manufacture in other states or not manufacture their products. Thank you for the opportunity to be here today and to testify.
Thank you for your testimony. And so everybody knows, the panelists have submitted testimony that is much longer, that is all made part of the record, so that will be available for everybody. Our next witness is Mr. Bruce Polkowsky, an environmental policy consultant. You're recognized for 5 minutes.
Thank you, Chairman Bridenstine, Ranking Member Bonamici, and Committee Ranking Member Johnson for the opportunity to speak to you about my experiences with EPA's Visibility Protection Program. Our national parks and wilderness areas are treasures of immense cultural and spiritual importance. Visitors expect and value clean, clear air. Those visitors generate billions of dollars and thousands of jobs at local gateway communities. And studies show that many Americans who may not visit these areas nevertheless value protecting visibility for future generations. Section 169A of the Clean Air Act establishing the national goal of preventing and remedying man-made impairment of visibility to our large national parks and wilderness areas, and requiring EPA to issue rules for states to provide reasonable progress towards that goal reflects the expectations and values of most Americans. EPA's visibility program has developed slowly, very slowly, from 1980 on to now. But it's done so in conjunction with advances in scientific techniques to understand the components and sources of the plumes and haze. And the regulatory program has developed slowly with input from states and tribes. Particularly when I was working on the regional haze rules at EPA, I took into account recommendations of the Visibility Transport Commission for the Grand Canyon that was established by Section 169B, and incorporated aspects of targeting the clearest days for protection and targeting the most impaired days for improvement. That came directly from the commission, as well as the glide path concept of moving towards natural conditions based on the Grand Canyons Commission's projected 40 to 70% reduction of sulfur dioxide across an 8-state region. So the program has also spurred technical innovation in the monitoring program, a network that has been formed for federal agencies, states, and academic institutions to develop equipment and techniques for routine capturing and analyzing the chemical makeup of atmospheric particles. Those techniques were proven in parks and wilderness areas and then became the foundation for the monitoring of those same particles in urban areas to implement the fine particle health standard. And EPA has fostered innovative implementation as well in some actions to control pollutants from sources subject to Section 169's Best Available Retrofit or BART technology, which must be implemented within 5 years. EPA has shown great flexibility in seeing value in attaining greater improvements over a longer period of time at a lower cost. EPA has also considered multi-pollutant benefits when weighing alternatives to controlling a single pollutant under BART. Over the nearly 4 decades since Congress established the national goal for our most treasured lands, there has been significant progress in improving visibility in many, but not all, locations. These improvements reflect emission reductions that lowered atmospheric concentrations of fine particles resulting from different regulatory programs, some focused on protecting human health, others on reducing harmful effects on public welfare and ecosystems such as acid rain, and some were taken specifically to address visibility. As the National Academy of Sciences noted in their 1993 report on protecting visibility, pollutant emission reductions that lower ambient concentrations of fine particles will improve the health, welfare, and visibility regardless of which regulatory program required the reduction. There is still work to do to maintain progress towards the national goal. States and EPA each have very important roles in continuing to make that progress. But given the complex atmospheric chemistry and meteorology that form and transport fine particles over long distances, coupled with the sensitivity of clean atmosphere to small increases in fine particle concentrations, EPA has a unique role in assuring that implementation plans of all the states and tribes fit together to continue to make progress towards the national goal. And one comment I have about the number of FIPS. In 1984, I had to issue 35 FIPS for visibility protection for the 1980 rules. So there is precedent in looking at when a new series of programs is required for the EPA to look state by state. So again, thank you for this opportunity, and I'm glad to answer any questions you may have.
Thank you, Mr. Polkowsky. Our next witness is Mr. Aaron Flynn, partner at Hunton Williams, previously served as legal counsel for the Science Advisor to the President at the White House Office of Science and Technology Policy. Mr. Flynn, you're recognized for 5 minutes.
Thank you, and good morning. It is an honor to appear before this subcommittee to offer testimony on EPA's Regional Haze Program. As the chairman just said, my name is Aaron Flynn. I'm a partner in the law firm of Hunton Williams. I've practiced environmental law as an attorney for the Congressional Research Service, for the White House Office of Science and Technology Policy, and since joining Hunton Williams in 2007, my practice has focused on the Regional Haze program. When Congress enacted the Regional Haze provisions of the Clean Air Act, it made very clear that the states, not EPA, should make the key decisions about how to implement the program. Congress directed EPA to develop rules to guide state decision-making, while states were tasked with weighing the relevant information, particularly information related to compliance costs and the relative significance of visibility improvements that different controls can achieve, and then deciding which controls were justified and which demanded too much. The early decisions of the D.C. Circuit acknowledged and strictly adhered to Congress's design for the program. In 2002, the court struck down EPA's first attempt at a regional haze rule in a case called American Corn Growers Association versus EPA, because that rule unlawfully constrained state discretion to make best available retrofit technology, or BART, determinations. EPA's rules would have effectively forced states to place greater weight on visibility impacts over costs or any of the other statutory BART factors. And in tossing out those rules, the D.C. Circuit stated clearly that EPA could not infringe in that manner on state decision-making. When EPA promulgated replacement regional haze rules in response to the corn growers' decision, including rules affording states broad discretion to adopt alternatives to strict BART requirements, the D.C. Circuit sustained those regulations against challenges that sought more restrictive policies. EPA began to stray from a commitment to recognizing state discretion, however, when implementation of the Regional Haze program began in earnest. In several early rulemakings to establish BART requirements for facilities over which EPA had direct regulatory authority and where no state had an opportunity to weigh in first, the agency established precedents for conducting BART assessments, precedents that were not necessarily clear requirements of the Clean Air Act or EPA's BART rules. Not only did those rulemakings establish questionable analytical practices, they also imposed requirements that sources install the most expensive emission controls operated to achieve the most stringent emission limits possible. That's a questionable policy in and of itself for older facilities that are undergoing emission control retrofits, as all BART-eligible facilities are. In subsequent rulemakings, EPA went even further. While state plans that adopted EPA's policy preferences were often approved, states that chose to use their discretion differently frequently faced plan disapproval and replacement of their policy decisions with federal plans imposing strict emission limits and expensive technology requirements. Many states challenged the disapproval of their plans in federal circuit courts, and some of those challenges have led to successful settlements and some limited victories. The vast majority of decisions, while acknowledging the state's role in the Regional Haze program, have nevertheless accepted arguments that could be interpreted to grant EPA broad discretion to disapprove state plans. Decisions from the 8th, 9th, and 10th circuits affecting facilities in Oklahoma, North Dakota, Nebraska, and Arizona have all deferred largely to EPA's judgment and granted no similar deference to state decisions. Litigation over EPA's actions during the Regional Haze program's first planning period may be coming to a close, but one case that is still in the earliest stages could set the tone for the next stage of implementation. Petitions for review of EPA's Regional Haze rule for Texas and Oklahoma have been filed in the 5th, 10th, and D.C. circuits, and whichever court hears the case will decide a number of key questions of first impression under the program, including the scope of state discretion under the Clean Air Act's reasonable progress provisions, which will likely be the key driver of any future regulatory requirements under the program. The court will also be acting on one of EPA's most controversial regional haze rules to date, one that would cost approximately $2 billion more than Texas's plan, while achieving no appreciable incremental visibility benefit. Indeed, EPA's own monitors confirmed that the agency's reasonable progress goals for Texas are being achieved today based on emission reductions that have already occurred, rendering EPA's plan unnecessary. I look forward to discussing these issues further, and thank you again for the opportunity to testify today.
I thank the witnesses for their testimony. Members are reminded that committee rules limit questioning to 5 minutes. The chair recognizes himself for 5 minutes. Mr. Flynn, is the Regional Haze program intended to protect public health?
Thank you for the question, Chairman. It categorically is not intended to protect public health.
Can you explain how this makes this rule different from the National Ambient Air Quality Standards?
Absolutely. The regional haze rule is aimed entirely at protecting visibility conditions. Section 169A of the Clean Air Act establishes a national goal that Congress set of achieving visibility conditions in what are called Class 1 federal areas, essentially national parks and wilderness areas, large ones, that is unimpaired by man-made air pollution. That national goal is phased in over a long period of time, a decades-long span of time. EPA has set a target goal for achieving the national goal of 2064. Even that date is not written to the statute, and it's simply a part of EPA's regulations. And EPA's regulations provide for the fact that states are free to determine whether the glide path to get to unimpaired visibility by 2064 is in fact reasonable. If it's not reasonable, states are free to push that deadline back even further.
Let me ask you on that. Did Congress intend the regional haze program to be used by the EPA to mandate specific controls at specific power plants? Was that the intent?
Congress certainly provided for the BART provisions, which envision states looking at and deciding whether specific controls are justified for specific facilities.
But that would be up to the states, right?
Exactly right, sir. And it is also, certainly there's nothing in the Clean Air Act that suggests that specific controls for specific classes of facilities are mandated by the Regional Haze Program. It is very much a process of weighing various factors, a process that is imbued with a vast amount of discretion in order to determine whether controls are justified at all and what controls those might be. And as you said, those decisions are intended to be made by the states.
Okay, thank you. Mr. Yeatman, would you agree that EPA's visibility goals at the heart of the regional haze regulations have already been achieved? Based on the pictures you showed us and compared to some of the pictures we saw before that, it would appear that most of these goals have already been achieved. Would you agree with that?
Thank you very much for the question. Indeed, I would agree that as Congress envisioned and as EPA envisioned, because this is an aesthetic regulation and not a public health regulation, that states could very well achieve the goals of this program through implementation of the Clean Air Act's public health rules. I mean, remember, the Clean Air Act is a ratcheting mechanism almost. Every 8 years, the new source performance standards for each source category must be reviewed and updated. Every 8 years, hazardous air pollutant standards for each source category must be updated. So the very nature of the Clean Air Act is to get more stringent with time. It is, as such, reasonable to depend on these ever more stringent public health controls to achieve these not public health, these aesthetic goals. Very briefly, if I might just touch upon the matter of the federal implementation plans that was brought up by my fellow witness. Indeed, I would note, I was under the impression it was 26 as opposed to 35, but that is neither here nor there. We can definitely get the official number in the record. I'd note only that all FIPS are not created equal. As I understand it, and as was explained in the testimony of my fellow witness, Mr. Polkowsky, the science wasn't there to implement regional haze rules for regional haze as opposed to individual plumes until the late 90s. The upshot is there weren't costs attendant to those FIPS. I mean, correct me if I'm wrong, Mr. Polkowsky, I'm under the impression there were controls at the Four Corners power plant that first round, but I don't know of any others. The upshot being there certainly weren't $5 billion worth of costs imposed by the federal government on unwilling states. So I think that's a difference that should be noted.
In my few remaining seconds, at this time, Mr. Yeatman, are additional and more stringent regional haze regulations necessary?
Oh, that's for each state to determine. That's for states to determine how much they value an aesthetic improvement.
Okay. My time has expired. I now recognize the ranking member, Ms. Bonamici, for 5 minutes.
Thank you very much, Mr. Chairman, and thank you to our witnesses for all your testimony and expertise. I basically want to focus on economic issues, but Mr. Polkowsky, you state in your written testimony, in your conclusion, that it's important to recognize that any pollution control required for protection of visibility will have collateral benefits for public health by reducing human exposure to fine particulate matter. And that is also spelled out with more detail in the letter that we submitted for the record from the National Parks Conservation Association, because we are talking about the same pollutants that contribute to visibility impairment, harming public health when we're talking about respiratory disease, decreased lung function, asthma attacks. So could you just briefly comment on that aspect as well, even though, yes, this rule was, the goal is for visibility, but there are, we often think about unintended consequences of legislation. These happen to be positive consequences that aren't necessarily what was the goal of the legislation.
Yes, you're absolutely correct in that when you control for visibility to aim at a certain target for like a BART determination, as we did in Arizona in the mid-'80s, in the early '90s. There were certainly benefits to exposure on tribal lands and nearby communities. So those exposures reduce, those pollutants being reduced, sulfur dioxide in that case is going to contribute to sulfate, lower sulfate levels, which will improve visibility. It will also mean less sulfate to be inhaled and less health impacts for the communities that are exposed. And that's true for implementing NACs will improve visibility if it reduces levels of fine particles. It works both ways. And
Thank you. Thank you. And I want to ask you, in your testimony, you talk about the long-term surveys that the National Park Service has conducted of park visitors, and you mentioned the value that visitors ascribe to clean air and scenic views. And you state that the protection of visibility in our most treasured parks and wilderness areas drives economic progress in those regions and nationally. So can you talk about, you did in your testimony, but expand on the economic effect of Haze, and how does that impact a visitor's experience and the economy of the local region?
yeah, well, as you already noted, one of the key factors is that as visibility improves, people actually spend more time at the parks, and that's very important because they spend more time, they spend more money, and as a Clean Air Task Force report in 2000 looked at, can we actually link improving, reducing emissions from power plants across mainly the eastern sector. This is before the full wave of controls that is sort of well underway in the east. Would that actually result in economic benefit across all these communities and more jobs? And the answer was yes.
And I do want to get in another question in my remaining time. Mr. Polkowsky, the testimony of some witnesses seems to suggest that the EPA should sort of rubber stamp a state's implementation plan, and I don't think anyone here is suggesting that. So could you talk about the oversight role of the EPA in implementing the Regional Haze program, and whether it's appropriate for the EPA to evaluate the state's implementation plan to ensure that the requirements of the program are being met?
It's a sort of required role of the Clean Air Act for EPA to have oversight on all state implementation plans for whatever program is being implemented. And in this case, as I mentioned in my oral testimony, we're dealing with the formation and transport over long ranges, hundreds of miles. And so coordinating the state plan, for instance, perhaps in Texas, with what the goals that were set in Arkansas for Caney Creek Wilderness is important. That's an important function to make sure that Arkansas is going to get what it's counting on in terms of emission reductions from another state.
And are there particular states, I think there was an example of Colorado where the approval process went through? And
well, Colorado took a multi-pollutant, multi-target approach for looking at not only visibility at Rocky Mountain National Park and other 12 Class 1 areas, but also looking at the nitrogen deposition and ozone on the Front Range. Combined all that together as part of the Regional Haze Plan, and EPA approved it.
Terrific. And my time's about to expire. I yield back. Thank you, Mr. Chairman.
Gentlelady yields back. I now recognize the gentleman from Texas, Mr. Nagebauer, for 5 minutes.
Thank you, Mr. Chairman. Mr. Yeatman, earlier this month, on March the 3rd, a lawsuit was filed by Texas Utilities on under the regional Haze issue, and the state of Texas had to respond to an egregious action by EPA. In this case, EPA waited more than 6 years to disapprove the Texas State Implementation Plan and replace it with a federal implementation plan that imposes interim compliance requirements that some people say cannot be met. You know, it's kind of interesting when EPA rejected the Texas plan based on that the action was on direct reasonable progress into source-specific analysis. And I think the 10th Circuit actually ruled that the source-specific analysis in determining reasonable progress was not required either by the law or the regulation. Isn't this just a kind of a bullying of the coal industry and trampling on the state's plans and rights?
It is certainly, I would argue, an instance of inappropriate treatment of the states, an inappropriate, an absence of respect for the state's decision-making, and indeed the state's authority pursuant to the Clean Air Act. If I might add, very briefly, at the outset of your question, you noted that EPA waited 6 years to approve to act on Texas's plan, and that's actually a big component of this regional Haze regime. The EPA has 18 months by statute to judge a state plan, and yet what it has done time after time and state after state is sit on these plans well past the 18 months. And what that does is, under the Clean Air Act, environmental groups are allowed to sue the EPA to compel missed deadlines. The upshot is, because EPA has not been meeting its statutory responsibilities to review state plans in a timely fashion, they've opened themselves up to what are known as these sue and settle litigations or lawsuits, whereby they become beholden to these ultra-rushed deadlines, these ultra-rushed rulemakings, of which Texas was one. So that is a facet I wasn't able to address in my oral testimony, but it is an important element of this regime as implemented. The agency simply has not been meeting its statutory responsibilities in reviewing these plans. They've left states twisting in the wind. But very briefly, I'll note that Texas submitted its plan in 2009 in accordance with 2006 guidance documents on regional haze issued by EPA. So Texas was using the most recent documentation. While EPA sat on the Texas plan, they issued updated guidance on which the Texas plan was judged. So it's sort of a, an after-the-fact review with respect, or I guess a bait and switch. I'm not sure what metaphor I'm looking for, but Texas based its plan on the rules that were in play when they submitted it. EPA waited 6 years, changed the rules, and then judged the Texas plan based on different rules. So it's, I'm glad I was afforded the opportunity to discuss that matter.
Well, it leads me up to the second question. It's my understanding that EPA's own monitors showed that the Texas had already achieved its visibility goals. Can you address that? How does that make sense?
You're exactly right. Again, EPA is going to base its regulation upon model results. However, real-world results, the last 5 years, the running average at the Big Bend National Park indicates that Texas has already achieved EPA's 2018 goal. So despite the fact that Texas has already achieved EPA's 2018 goal, EPA's own goal, and despite the fact that these EPA's controls don't result in any visibility benefit, and they cost about $2 billion, the EPA proceeded apace. So it is, that's another troubling aspect, certainly, of the Texas FIP.
So let me understand it. So waited 5 years, and then Texas was already meeting the goal, but EPA denied their plan and said, we want you to do a new plan, which, as I understand, will force Texas to spend $2.8 billion to increase an already 28.4 mile view by the length of 7 football fields. Does that make sense? I think that's $2.8 million a yard.
That sounds, now cost figures I have heard I guess perhaps closer to $2 billion. Nonetheless, we're talking billions of dollars for benefits that are literally invisible. So the only dispute I would have with your comment respectfully is that Texas achieved the EPA's goal over the last 5 years while EPA was dithering on its plan.
Thank you. I yield back.
Gentleman yields back. I now recognize the ranking member, Ms. Johnson, for 5 minutes.
Thank you very much, Mr. Chairman. Mr. Polkowsky, I appreciated your quoting President Teddy Roosevelt in your testimony, as he was surely someone ahead of his time in contemplating issues in environmental health. In 1908, in a speech given to mark the opening of the Conference on Conservation of Natural Resources, he said, "But the time has come to inquire seriously what will happen when our forests are gone, when the coal, the iron, the oil, and the gas are exhausted, when the soil shall have been still further impoverished and washed into streams, polluting the rivers, denuding the fields, obstructing the navigation. These questions do not relate only to the next century or to the next generation. It is time for us now as a nation to exercise the same reasonable foresight in dealing with our great natural resources that would be shown by any prudent man in conserving and widely using the property which contains the assurance of well-being for himself and his children," unquote. More than 100 years later, it seems that we still are working against the forces that would keep us from achieving the vision laid out by President Roosevelt when he had this in mind. Why is it important that we continue to improve the air quality for our national parks and around the country? Is it simply good enough to achieve some arbitrary standard, or should we strive to make good on the words of President Roosevelt?
Well, I certainly think we should make good on the words of President Roosevelt, and I think that sort of having a false dichotomy of looking at this as visibility protection or public health is it's wrong. We live in one atmosphere, and we should be striving to get that atmosphere as clean as we can, to improve public health, to improve the aesthetic quality of our parks and wilderness areas as one program moving forward. And I think the history of looking at EPA's visibility protection program has been one of applying careful science to exactly that goal.
Thank you. The Clean Air Act's Visibility Protection Program is grounded in science, showing that reducing pollution that scatters light, like sulfur dioxide, nitrogen oxides, and particulate matter, results in cleaner and clearer air. Visibility impairment is measured in deciviews, a measure of the perceptive change in visibility, where the higher a deciview value, the worse the visibility impairment. In his testimony, Mr. Yeatman suggests that because the average person may not be able to perceive or visibly discern the reduction in haze achieved through the additional controls required by EPA, and because of that, the controls are not worth the added cost. Do people actually notice visibility improvement? Is a 1 deciview of visibility improvement, or conversely degradation, actually perceptible to the national park visitor? And can we explain why emission reductions resulting in less than a deciview of improvement are needed to advance the Clean Air Act objectives?
The answer is that any given view can take anywhere from a half a deciview to be visible to several deciviews. But people, in general, on views that incorporate a wide aspect of contrast change and enough sky color, can see a 1 deciview change. A study in Phoenix looked at a deciview change over 1 deciview at a time from 14 deciviews to 32 deciviews. And people ranked those, 385 people ranked those in absolute order from good to bad. And that wouldn't have happened if they couldn't perceive a change of a deciview. And so it's really important that we also make progress towards improving these deciview readings at these parks and wilderness areas, and you can only do that incrementally. And one single source may only move a fraction, but the courts and EPA have said that, this is the way you move forward.
Thank you very much. My time is about to expire.
The gentleman from Louisiana, Mr. Abraham, is recognized for 5 minutes.
Thank you, Mr. Chairman. Mr. Polkowsky, in your testimony, you mentioned innovation implementation of EPA's rules and orders, and I would probably argue that I would use a different adjective that probably in this public forum would not be appropriate, in my opinion. I've heard when Mr. Neuberger, you said, Mr. Yeatman, that Texas had achieved its own goal, and the states are doing a wonderful job. I've heard that this implementation of EPA's rules in this instance would cost billions of dollars and increase energy cost, as you said, Mr. Schroedter. And again, I don't think anybody on this panel doesn't want clean air and beautiful, pristine national parks, but I think I could argue that with the billions of dollars, the increased energy cost, states doing a great job themselves, that the consumer's not going to be able to afford to go to the parks if this goes into law. Now, I'm a physician by trade, so I have to make decisions on objective data and hard science. And Mr. Yeatman and Mr. Flynn, I'll address this question to you. What science and modeling has the EPA used to come up with this? I mean, I can't find any, and maybe I'm missing something, but I'll let you respond.
Thank you for the question. There are no tricks. I mean, this is what I demonstrated to you is precisely what EPA is bringing to the table. And with respect to the previous discussion about decaview and visibility, that Oklahoma picture, the side-by-side one, that was 2.89 decaviews. The Texas picture, that was 0.5 decaviews. Now, according to peer-reviewed research, there is a 20 to 40% chance of the average person being able to view a 1 decaview change. We saw that difficulty. It was evident when we compared the
But the
images for Oklahoma.
EPA claims that the average person can pick up a single decaview. That can't be correct.
Well, to be respectfully, I think EPA's language is likely. I mean, so they use hedge words such as that. I don't think they've ever definitively said that 1 decaview indeed would be visible. And indeed, the agency never directly takes on, for obvious reasons, the putative benefits of its rule.
Thank you, Mr. Chairman. That's all I had. I yield back.
Gentleman yields back. I now recognize the gentleman from Michigan, Mr. Muhlenar, for 5 minutes.
Thank you, Mr. Chairman, and thank you, panelists. Mr. Yeatman, I wanted to ask you about the sue and settle lawsuits and this concept that, according to your written testimony, every EPA disapproval of a state regional Haze plan and every EPA federal implementation plan has been rendered pursuant to a sue and settle lawsuit between environmental special interests and the agency. I wondered if you could explain for us how that works and what are the practical ramifications for that.
Thank you thank you very much for the question. So it works. I laid it out in a previous answer. Really, it's a function of EPA's inability to meet its statutory responsibilities. I mean, EPA's leaving states twisting in the wind while it waits years to respond to these plans. And because the statute affords special interest the opportunity to sue the EPA to compel the agency to meet its non-discretionary duties, what we have is a scenario whereby EPA sits in the plan, exceeds its statutory responsibility, opens itself up to litigation, that then leads to the practical ramification is a rushed deadline. State after state after state has complained that EPA is imposing these costs, these billion-dollar costs, and conducting these rulemakings on an ultra-tight schedule. So, of course, a rushed rulemaking is a shoddy rulemaking. So it's the sue and settle itself, in this instance, is a function of the agency's failing to meet its statutory responsibilities in reviewing state plans, and the ultimate impact are rushed, poor rulemakings.
And what is the state's role in that? I mean, they would be a stakeholder. Are they involved in that process?
That's a wonderful question. I'm glad you brought that up. in the worst element, if you will, of the sue and settle component of this regulatory regime is that the agency has actively litigated to oppose states from intervening in these sue and settle lawsuits. So that is, states are the regulated entity. They are EPA's partner under the cooperative federalism framework. So states become aware that these negotiations are occurring between EPA and special interests under the auspices of a district court, federal district court. States want to intervene. North Dakota has tried this, Oklahoma has tried this, Texas has just tried this. They want to intervene, protect their interest. And again, cooperative federalism, they're the regulated entity. EPA, when they haven't actively litigated to oppose state participation, they've ignored state stakeholders at the negotiating table. So that has been a very troubling aspect. I mean, perhaps the most egregious affront to cooperative federalism has been EPA's activity in the courtroom with respect to these sue and settle lawsuits.
Thank you for clarifying that. Mr. Schroedter, am I pronouncing it right? Thank you. In your written testimony, you mentioned the regressive economic nature of this regulation, and I wondered if you would go into more detail for us on how this rule widens the income inequality gap.
Yes, in my testimony, I point out that, for example, with respect to the impact on households, that, first of all, Oklahoma households spend an average of 12% of their after-tax incomes on energy. 827,000 Oklahoma households earn less than $50,000 per year, and they spend 21% of their after-tax incomes on energy. 381,000 households with annual incomes of $10,000 to $30,000 spend 25% of their after-tax income on energy. So you can imagine if we're talking about rate increases of 10% to 20%, which is what's going to happen in Oklahoma, that these are going to be the most impacted, the lower income and those on fixed incomes. And it's a regressive ramification for Oklahoma households.
And how about the effect on small businesses? Is that something that would force businesses to close shop and or move to another state because of these costs?
Well, on small businesses, you know, the energy cost can make a difference between making it and breaking it. If you're on the bubble, let's say, I mean, if you're barely getting by and you get hit with a 10 to 15% increase, not only that, but then you're looking at more increases. Those businesses, those small businesses are likely not going to make it. They're going to shut down. Whether they move to another state, I think, is more for the larger industries, my members, where if the electric bills become such that they are no longer competitive in their operations, they're going to move the production. What you'll see is you'll see moving production to other states, and if other states get hit, then what'll happen? Offshore, perhaps, because it won't be competitively economic to manufacture the product. So that's a concern, a big concern. Thank you.
The ranking member has requested 30 seconds to make a statement without objection. Would that be all right? Okay.
Thank you, Mr. Chairman. We have no other members on this side. And I just wanted to request that we put into the record a Sustainable Energy in America fact book from 2016, Bloomberg New Energy Finance, that found, importantly, surging renewables build and coal retirements have not triggered a dramatic leap in retail power prices. Average retail electricity rates across the country remain 5.8% below the recent peak, 2008, in real terms, in part due to cheap generation from natural gas. So without objection, I'd like to enter this into the record.
Without objection,
Thank
so
you, Mr.
ordered.
Chairman.
You're welcome. Real quick, on the sue and settle issue, my understanding is the sue and settle rulemaking that affected the state of North Dakota was actually a lawsuit that happened in California. Are you aware of that?
Yes, Chairman.
Now, explain to me why the EPA would sue to prevent North Dakota from having any kind of involvement in that rulemaking.
A matter of legal strategy. The agency, or ultimately, it's not the EPA that's suing. It'll be an environmentalist group that will bring the suit to compel EPA to do its duty. It is the Northern District Court of California in the Bay Area is perceived by such litigants as being more favorable to their cause, if you will, than other courts. So that's why they wouldn't go to North Dakota, a federal district court. That's why they would say, you would find this unusual arrangement whereby EPA is negotiating with an environmental special interest in a Northern California court, North Dakota's regulatory responsibilities.
Could EPA not, okay, so could EPA not working with the state, could the EPA not bring North Dakota to the negotiation?
That was the very suit that North Dakota AG Wayne Steinham tried to intervene and that the agency actually litigated to prevent. So it was...
When you say the agency, who's the agency?
Well, the Environmental Protection Agency working with the Department of Justice.
So the agency did sue to prevent North Dakota from having a seat at the table?
Oh, yes, I guess legalese, slight difference. I mean, they litigated, they were already part of the suit, but as the respondent, they joined with the environmental special interest to prevent intervention of right by North Dakota.
That is absolutely bullying states. I now recognize the gentleman from Alabama, Mr. Palmer, for 5 minutes.
Thank you, Mr. Chairman. I just want to follow up on this issue of how higher energy costs impact families. To your the point that was made, families with incomes below $30,000 spend almost a quarter of their disposable after-tax income on household energy. That's just now, right now. Among those are senior citizens, which make up, I forget, 20-something million households. Their median income is somewhere below $34,000 a year. It has a tremendously negative impact on their disposable income. And it's also interesting to note that the National Black Chamber of Commerce has addressed this issue in regard to the Clean Power Plan. And I think this goes along the same lines. And they project that if these EPA regulations go into effect, that it's going to increase poverty, household poverty among African Americans by 23% and by 26% among Hispanic families. That said, there's some issues here that are very troubling to me, and the gentleman from Michigan, Mr. Molinar, touched on it, and that is this whole issue of sue and settle and consent decrees. I've done a substantial amount of work on the issue of consent decrees at the state level, and also looked at the federal level. As a matter of fact, I co-authored a paper back a few years ago on how state legislatures can protect themselves. But what's going on right now is outside of what we've seen in years previous. And Mr. Yeatman, you can respond to this. Why would you think the EPA hasn't fought these suits through the courts, including going all the way through the appeals process to get a judgment rather than simply entering into a consent decree? You can use your imagination.
It is a fantastic question, and that's an issue we've been pressing at CEI, is for the agency to defend its discretion, to defend its prerogatives, to establish its own priorities, instead of being beholden to environmental special interests and having these unelected, again, special interests, in effect, dictate the agency's limited resources. It is, I'm loath to put a cause behind it. I can only find it, I find it inexplicable.
Well, I can tell you this, in cases that I studied where states and the federal government in some cases, but most of my work was at the state level, it was very evident that state agencies wanted to enter into a consent decree because it was their way of bypassing the legislature. They were able to increase spending, expand their programs by court order. I mean, what a wonderful opportunity to do that. I would go, again, using our imagination, I would go so far as to say that it appears to me, Mr. Chairman, that the EPA is acting in collusion with environmental groups to achieve their agenda, whatever it may be, of regulating outside their statutory authority. And I think that's a huge issue. Would you like to respond, Mr. Yeatman?
If I might speak to that issue, for whatever reason, a pioneer in this regional haze regime has been EPA Region 6. And that's Texas, Louisiana, Arkansas, Oklahoma, and New Mexico. In 2010, so a number of these sue and settle consent decrees, one consent decree that affected Region 6 states. We know it was brought by Wild Earth Guardians in 2010. We know that the then EPA Region 6 Administrator Al Armendariz, who you might remember resigned in some controversy when he compared his enforcement style to that of a crucifixion, we know that he used to work at Wild Earth Gardens. We know that after he resigned from the EPA, he joined the Sierra Club. We learned from a FOIA that there were contacts between Al Armendariz and his former colleagues at Wild Earth Guardians regarding the sue and settle consent decree or the sue and settle process, and he was actually told by the EPA, whoa, you cannot be doing that. Like,
Well, let me tell you what else we've discovered in that regard. We know that the EPA was holding seminars to teach their employees how to avoid FOIAs and National Archives and Records requests by using websites set up by outside groups and maintained by outside web groups. So there is collusion here, and Mr. Chairman, it may be in our best interest to hold a hearing to see if there might even be criminal activity here, because it seems to me that there's a fraud being perpetrated upon the American people. And I'm going to make this as my closing statement. What really bothers me about this is the EPA is trying to regulate everything from ditch water to the climate, now the aesthetics of the environment. Yet they covered up one of their own scientists' report in Flint, Michigan about the lead in water up there. They released millions of gallons of toxic material into the creeks in Georgia and denied that they did it and finally had to admit it. And then by their own action released millions of gallons of toxins into the Animas River that flowed all the way down into Colorado and Utah and New Mexico and tried to cover that up. I think we need to dig deeper into this. I yield the balance of my time.
Gentleman from Alabama, Mr. Palmer, makes great points. I recognize, remember, this is a fly-out day, so they're not likely to hold votes open for very long. We've got about 10 minutes left. I recognize Mr. Babin from Texas for 5 minutes.
Thank you very much, Mr. Chairman. And I'm just going to be very, very brief. And I appreciate what Mr. Palmer, those questions that he just asked, and right along those same lines. In your written testimony, Mr. Yeatman, you explain how EPA repeatedly has employed a supposedly independent consultant to second-guess state determinations on regional haze. However, during the same period, this same independent consultant has also worked on regional haze rules for environmental special interests, like the Sierra Club. Does this lead you to question the EPA's independence? And I would like for you to explain, and then also, to your knowledge, how long has this type of arrangement been going on, and which state determinations have been affected by her involvement? Thank you.
Thank you for the question. Yes, this raises serious conflict of interest concerns. This independent consultant has been employed by the Sierra Club with the National Parks Conservation Association on, I believe it's 6 different regional haze rulemakings. I can, in the record, I can put down the states. I don't know them off the top of my head. At the same time, she's been employed by the EPA for 5 different rulemakings. So this is the same, during the same administration, the same regulatory regime, the same independent consultant. And just to clarify what's going on here, the states spend thousands of hours on these regional haze plans. These regional haze plans are thousands of pages long. It's a lot of expertise. It's a lot of resources that states expend on them. This independent consultant, who again seems to be playing both sides of the field here, based on her analysis, EPA is disapproving the state plans. So we've got on the one hand, a co-sovereign of the United States, thousands of hours of work. On the other hand, that work being effectively shunted aside, cast by the wayside, due to the input of this one contractor. So it is note one other point with respect to this. Sierra Club is one of the environmental special interests that has been involved in each of the sue and settle lawsuits that have led to these the deadlines for these rulemakings. That means that EPA, before the courts, and Sierra Club are adversaries on this, putative, or supposedly, in our adversarial legal system. They're on opposite sides of the coin. However, at the same time, they're employing the same independent consultant. I mean, it again raises these I would argue, serious conflict of interest concerns.
Absolutely. I thank you for that. And Mr. Chairman, and to save time so we can go vote, I yield back the balance of it.
I'd like to thank the gentleman from Texas. I thank the witnesses for their valuable testimony today and the members for their questions. The record will remain open for 2 weeks for additional comments and written questions from the members. Mr. Babin, if you have additional questions, you can certainly submit them for the record. This hearing is adjourned. Thank you.